Tuesley Hall Canopa.
The first thing to understand about an agreement not to compete is that it's a very intricate area of the law. And so there's sometimes a misleading sense of simplicity that you think, well, it's an agreement. Whatever it says is what it says. But in truth, an agreement not to compete can only be enforced if it's reasonable. And what is reasonable is going to vary quite a bit by the circumstances. Certainly there are court cases throwing out non-competes, and so sometimes people get the idea that they're never enforceable, that they're not worth the paper they're written on. That isn't true either, but there are defined principles that apply in Indiana, which are somewhat different from Michigan, and which are still somewhat different from any of the other states. Often you will also see agreements not to compete in the sale of a business context. So if I sell my business to someone, that buyer may require that I agree not to go open a competing business down the street and take away the customers. Courts will generally allow more restrictive agreements in that situation than they would with an employment situation. There are also, beyond the legal considerations, a lot of practical considerations. It can be very expensive to fight an agreement not to compete battle in court. And so sometimes employers decide the loss of this person is not worth it to spend the legal fees to go try to fight him or her in the new employment situation. But you also have to think about what kind of message that sends to the other employees. You may or may not want the word getting around that you won't stand behind your agreements. Or if you're on the other side of that, if you've just hired someone away from a competitor and find out that that person is subject to a lawsuit, you might decide this new employee is not worth the investment and go ahead and release him or her. At the same time, you got to think about what message that sends to your competitors if you can be intimidated into not hiring people. So the practical really layers on top of the legal when you're faced with a challenge in court. And I guess the bottom line is that there just isn't a cookie cutter approach to this. When you're crafting one of these agreements or when you're faced with your obligations under one of these agreements, you really have to look very carefully at the circumstances and at the law of the state that you're operating under.
Tuesley Hall Canopa.